Good morning to all of you. Today we are going to discuss a case law on the allotment of plots which are lying idle but which are meant for the public purpose, whether they can be allotted to the landless poor or not. This is the question in dispute. Now, while deciding the case of Perala, Jyotsna and others versus State of AP and others 2020, the single judge bench of AP High Court, Sri M. Sachranamurthy, while disposing the WP number 18,104 by 20 on 22nd October, held that the land reserved for public purpose cannot be utilized for any other purpose. It cannot be utilized for issuing of pattas to the landless poor by the state. This is the judgment he has given. Right? Now, if we go to the factual background, actually during the year 2016, the state acquired the land to an extent of about 8 acres in survey number 67 by 2A and 67 by 1B and 3 also, in a village called Nagandla. Actually, this site is located in its hamlet by name Sudivarpalam in Prakasham district, Ongole. Right? The total extent is 8 acres 23 cents. Right? So this is purchased by the state for the allotment of house sites to the poor people. Right? According to the AP Gram Panchayat Act and also mainly AP Land Development Layout and Subdivision Rules 2007, right? They have prepared the layout and they have left certain places. Number 1, for the school, for the hospital, for the park and for the open streets. So this is all for the public purpose. They have left the place. Of course, no school was constructed, no temple was constructed, no church was connected, no community hall was connected, no hospital was constructed. It is lying vacant. This is the factual position. Now, the present state, since they are vested with the Gram Panchayat is the controlling authority over the so-and-so said places. Right, so since they are vested with the Gram Panchayat, the state wanted to allot these house plots for the houseless poor under Navrattalu Peda Intiki Pedavariki some program. The state government has started that program. So they have allotted, they wanted to acquire this land for the purpose of allotment to the landless poor. So, but the local people like Perala, Jyotsna and others objected to the same, stating that they are meant for public purpose. They should not be allocated to these pattas. So they have filed a writ petition before the Honorable High Court. So they contend that once the land is assorted, the land is reserved for public purposes, it cannot be converted into house sites and assign the same to the public. In other words, this land cannot be alienated to the third party, defeating the common rights of the villagers. Of course, there was a little difference in the affidavit. They said that it is for communal purpose. No doubt, communal purpose or public purpose. So, according to the provisions of AP Panchayat Raj Act 1994 and AP Town Planning Act 1920, and of course, now this is more important, AP Land Development within brackets Layout and Subdivision Rules 2017. Right? The earmarking of these plots is for public purpose, maybe communal purpose. So when once it is for the public purpose, they should be used. Why they are left? Because the public should get clean air. The public should have clean, the so-called sanitation should be, they should have hygiene, very good hygiene. So there should be sufficient ventilation. The roads should be wide enough to transport them to other places, and there should be a park for getting clean air, health for a hospital. Like for that purpose only these lands were kept vacant. This area, particular area, is the kept vacant. No doubt, the Gram Panchayat is the custodian of the property according to Rule 7, Subclass 7 of the AP Layout and Subdivision Rules 2017. So therefore, that too according to Rule number 13, they have stated, according to Rule number 13, they should not alienate the land to any other purpose. Right? Of course, the government says that since the area or the extent land is vested in the Gram Panchayat wanted to develop the same and allocate the same to the household sphere, which is an immediate necessary, and they stated that program Navaratnalu dash Pedala Intiki Pedalandariki Illu. So since there is no other land available, they wanted to allot these sites to the poor people. But now the court did not agree. The court held that even though the intent of the state is definitely to allot certain plots to the households people who are needy people, but to convert the plot into house sites and allot them to the landless poor is nothing but defeating the public purpose. So with this, the people would lose the so-called chances enjoying of clean and decent surroundings, sufficient light, pure air and water, and good sanitation and other civic amenities. So therefore, they have cited, the High Court has gone through the previous judgments like very famous, MC Mehta versus Women of India 2001. Reserving any site for street, open place, park is a public purpose, and it shall be used and enjoyed by the general public, not for the other purposes. Therefore, here they have actually at length discuss about the doctrine of public trust, which is a Roman Empire jurisprudence theory. So, doctrine of public trust they have discussed in detail. And I have also cited the stare decisis, that is Bangalore Medical Trust versus B.S. Muthappa, 1991, where the site allotted for park, the municipality, the Bangalore Corporation, they wanted to give it to a corporate hospital for starting a hospital. There, the court held that no doubt service is the motto, but what is the so-called earning is the objective. So they should not be allotted for other purpose. So with taking into consideration of all these judgments, the court held that the allotment of house sites is illegal, arbitrary, and state is not directed to assign the lands. Because why I am making this video is, please remember, the lands which are meant for public purpose, they should be allotted for the same only. No doubt there may be no constructions, there may be some occupations, but once the time comes, the occupants, definitely the encroachers will be taken away. I think I have seen in the TV very recently some politicians saying that dear people, I wanted to allot certain lands to you, but people have gone to the court, and court is not allowing us to proceed further. So please remember, you have to do anything according to law. If you don't do anything according to law, definitely such petitions will succeed, right? So this is a good case. You can cite it because it is generally for the public purpose. So many incidents of such type taking place. You can mention this case as a precedent or a celebrated case law. Thank you.